This is Collins versus Hearty Investment Trust. Each side will have 15 minutes to present their arguments, and the appellant may reserve up to 5 minutes. We're ready to proceed.
May it please the court, my name is John Cliston, representing the defendants. In this case, may I reserve 4 minutes?
That would be fine. Thank you, counsel.
I probably will never be a judge, but I've read enough cases to know that there are easy ones and hard ones. The hard ones, perhaps, where the law dictates one result and notions of fairness or justice or even sympathy suggest another result. The easy cases where the law and those other factors line up together. This case is both. It's both hard and easy. The hard part first. There is some evidence in the trial record that Hugh Hearty intended his share of this trust, this Hearty Investment Trust, to go to his wife. There is evidence to that effect. There's also evidence that over a year passed from the time he signed that so-called codicil until he died, a year where anything could have happened and any minds could have been changed. But there is some evidence that he wanted that money, that share, to go to his wife.
Is that, and I apologize, I'm going to stop you there because, and I know it's soon, but is there evidence of his intent to make an inter vivos transfer or a transfer of that exercise of that power of appointment after death?
I don't believe there was any instrument that did that. He had a will, 2 wills in fact, that he had executed, but I don't believe that share had been transferred or appointed before that.
So there's a lot of argument between the parties and some of the real estate of the judgment entry regarding the ability to make an inter vivos transfer. I'm trying to understand what evidence we're going to find in the record of his intent to make an inter vivos transfer.
There was a prior avenue for making a transfer under the previous version of the trust that allowed that inter vivos transfer. But the parties in this case, the siblings, wanted an easier way. That way had all kinds of requirements. It required a certain form, etc. But they wanted an easier way to do that. And they decided on amending the trust to make that manner of transfer easy by will, the way most people transfer their property upon death. I don't believe he had exercised any power of appointment before. But to pick up where I left off, the law does not dictate the result that Hugh Hearty's share be transferred to his wife. The parties, the siblings, Hugh Hearty himself signed that Second Amendment. That was their intent. Their intent was enshrined in writing to make a transfer of their share possible by will and by will only. That was an easy way. They wanted an easier way. That was an easy way. It's the way most people transfer money upon death or assets upon death. And that's what they decided on. The trustee liked it because it made his job easier. The gentleman, the attorney who drafted the Second Amendment, said he wanted to make a testamentary form of transfer because that's what the siblings wanted. Hugh Hearty signed that. That was his intent. That Second Amendment requires a will. If the court would look to the last sentence of that Second Amendment, it says, in default of the exercise of this limited power of appointment, the share must pass to the credit bypass trust. That word, 4-letter word, this, is often overlooked, but in this language, in this context, it is very significant because it's a directing word. It's a word that points the reader to the power of appointment found in the paragraph, found previously in the paragraph. It's a definite article that shows that this power of appointment was only the power of appointment mentioned in the previous language, only a power exercised by will.
If I may though, doesn't it say that each of the grantors may appoint heirs in a trust share by last will? It doesn't say they shall do it, because they can also do it by trust too, so there's a few different
because they didn't have to. They could simply let it go, not appoint a share, and it passes automatically to the credit default trust. The language about the trust is a trust in the context of a will. In other words, if you have a will, and in the form of that will you set up a trust, then the trust has to have these requirements. But overall, this paragraph provides one way only, and that's by will. Or, if in default of this limited power of appointment, the share shall pass to the credit bypass trust. There is much talk in the first trial court's opinion and in the plaintiff's briefs about equity. But equity cannot override these provisions. Equity cannot override Ohio statutes dealing with wills. The parties provided for a will, and wills under Ohio law are creatures of statute. The statute has definite requirements. 2 people must witness, 2 people must subscribe and attest to the will. Equity can't override those requirements. There's the maxim that decides this case, in effect, equity follows the law. Equity can do a lot, but it can't override statutes. The plaintiffs have suggested that the probate code in this case is irrelevant, but the parties again made the probate code relevant by requiring a will. A will, again, is only a will as defined by the probate code, and it requires certain things that were not present on this so-called codicil. Ohio statutes even allow for a will that isn't quite a will. Revised Code 2107.24 says, if you don't quite meet the requirements of a will as stated in the other code section, we'll still treat it as a will, but 3 requirements have to be met. 2 people must witness the decedent sign that. 2 people must prove that by clear and convincing evidence, and it has to be done in a probate court. Those 3 requirements have to be met. So there is a kind of default provision in the code, but again, even that default provision wasn't met here. There were not 2 witnesses who saw Hugh Hearty sign this so-called codicil. Again, any notion of equity being involved in this case simply can't override those statutory requirements. That's the hard part of this case, because the law clearly dictates one result, and yet there were facts showing that Hugh Hearty wanted his share to go to his wife. The easy part of this case is this issue of debts and expenses. We have, under Ohio law, a probate process for dealing with that. An entirely separate division of this court, of the common pleas court, was set up to deal with marshaling debts and expenses and assets, doing it in an orderly way, an official way, with accounting before a court who reviews these things. That process is the context of the debts and expenses issue we have here. The trustee was given great discretion under the trust to do a lot of things, including determine whether the debts and expenses of the estate exceeded the assets available to the estate. And in his discretion, Mr. Glenn, through his attorney, was requiring an official accounting of the debts, expenses, and assets of this estate. In December 2008, the attorneys and executor of the estate represented that the estate had only about $1,900. Just 11 days later, when they filed the first accounting in probate court, that $1,900 and change turned into $170,000 and change. Where did that money come from? No one seems to know. The executor was asked repeatedly at trial, where did that money come from? Where did all those assets come from? And he said he didn't know. But it was 11 days after he represented that there was about $1,900 that suddenly there's $170,000. And 4 months later, there were hundreds of thousands of dollars more. There's this talk of this Holmes partnership that provided a substantial chunk of assets. The Holmes partnership is significant, but it's really a red herring as relates to the amount of money that was available. That first accounting in January 2009 showed tens of thousands of dollars of cash on hand, not including the Holmes partnership. 4 months later, the Holmes partnership was liquidated and provided hundreds of thousands of dollars more. But even in January 2009, without that partnership, the estate still had over $170,000, including cash on hand. Again, where that money came from, no one knows, but there's little doubt that it was there. Mr. Hearty, of course, was deceased, and he wasn't earning additional money. That money was there, it just wasn't reported to the trustee as he required. There was more than enough money then to pay all of the debts and expenses. And the proof positive of that is found in the plaintiff's brief, where they start off by saying that the trustee has never paid a penny of the debts and expenses. Point well taken. A penny never had to be paid because the debts and expenses were all paid without any trust money from the available assets, assets that were so significant that even after paying all these debts and expenses with executive estate assets, the estate still found it within its power and the executor's discretion to pay over $250,000 of those assets directly to Ms. Siegenthaler. There was more than enough money.
Counsel, you're starting your rebuttal time.
Thank you.
May it please the court. My name is Michael Elliott. I'm here on behalf of the estate of Hugh Hearty. I had the pleasure of representing the estate at trial along with my partner Lawrence Scanlon and Tom Haskins, who represented Lisa Hearty. We're here once again to uphold the decision, order, and ruling by the trial court that Lisa Hearty, Hugh Hearty's widow, is entitled to his share of a trust created by him and the other beneficiaries named as defendants in this action. The trust, as you know, is the Hearty Investment Trust. At the time of Hugh's death, it had more than $7 million in assets. Hugh Hearty's 1/5 share totaled more than $1.4 million. The reasons stated in our brief show and demonstrate that the lower court's ruling should not be overturned, either in whole or part. I'm particularly troubled, we'll talk about this later, but when we, once again, frantically, in 10 or 15 minutes, delve back into the facts that were all established after years of litigation and days of trial. But we'll talk about that in a minute. But there should not be an overruling, but an affirmation of those decisions by the lower court. Real briefly, this court should uphold that decision that found that the power of appointment, not a codicil, not being asked to probate, but a power of appointment was vague and ambiguous. That an otherwise defective instrument could act as a power of appointment. And also that the trial court has inherent power to give effect to the manifest intent of the parties. Those rulings were all rulings that the lower court made in two separate opinions and decisions. There was also a separate finding of fact that was referred to, and this is really a finding of fact that shouldn't be disturbed absent a manifest discretion or manifest weight of the evidence. In other words, a miscarriage of justice, where that court, weighing all the evidence, going through the analysis, and finding a shortfall in the estate, or only $1,900 at the time. We can look at the language. It says, upon death of the decedent, those funds that are not available or reasonably available, subject to the costs and expenses of the state, shall be paid. There's not an analysis that allows the trustee of this estate to say 6 months later, well, there's going to be a windfall here. It's not even a windfall. We'll talk about that. It was a Homes Partnership interest that Lisa Hearty had to bring a separate lawsuit to get. But those monies were not there, and that's clear at the time that Hugh Hearty passed, or for several months afterwards. Going back to the first assignment of error and whether or not this instrument met or satisfied the terms of the trust. This court's prior ruling and instruction to the lower court was it asked it to make a finding as to whether or not there was an ambiguity. The court in its second, and I'll refer to Hearty 2 versus Hearty 1 throughout the remainder of my discussion. But in that Hearty 2, the trial court entered a finding that the language set forth in the grant of power is vague and ambiguous. You go back to Hearty 1, the trial court explains how it made that determination. The trial court explained in that ruling that the language in the trust does not specify a single manner or way a beneficiary must appoint his or her trust share. The language requires specific reference to the limited power of appointment, but does not require that it be admitted to probate. Just to be clear, we've never asked that this, in this forum, that this power of attorney be probated, or that it be duly approved and allowed. In fact, it couldn't. We know it can't pass the muster of probate. But that's not the issue in front of this court. That wasn't the issue in front of the trial court. It went on to say, furthermore, it arguably eliminates the need to execute a specific form to exercise a power of appointment. Having determined that that language is ambiguous and having a reasoned basis for that conclusion, the trial court next examined the grantor's intention and whether executing the document effectively carried out his intentions. Again, it's disturbing to me that, once again, after he, and maybe it's because I've been involved in this case for years and years and years, but the lower court unconditionally found as a finding of fact, and I'll quote it, there is no question Hugh Hearty intended to exercise the power of appointment in favor of Lisa Hearty. That was something clearly established by the plaintiff below. And to attack that in this proceeding, it is really unfair. You can attack the legal issues, you can attack that, but don't attack the facts, the findings of facts, after having gone through days of testimony, days of examining and weighing those. So once again, the trial court was at a point where it established the intention and had to make a determination whether this language satisfied, effectively carried out the intention of the grantor, also the beneficiary. The document itself states, I am hereby intending to exercise any power of appointment granted to me by the trust agreement between the Hearty Investment Trust, also known as the Glenn Trust, with John Glenn as trustee, and I hereby give, devise, and bequeath all the residue of my estate, whether real, personal, or mixed, wheresoever situated, including property over which I may have a power of appointment to my wife, Lisa D.C. Gonzalez. Additionally, I hereby give, devise, and bequest any power of appointment and any property that I may be entitled to, including but not limited to, any distributions from said partnership to my wife, Lisa D.C. Gonzalez, signed Hugh Hearty, dated February 17, 2007, about 10 days after that instrument was created, and a few short weeks after the last meeting between the Hearty family members. And if we want to bring up facts, there's a lot of facts here, a lot of facts that were uncovered during the trial that, for a variety of reasons, won't be brought up in this proceeding. But one such fact, in preparing for today and reviewing, I realized that it was something that I hadn't remembered, because now we're, I think, about 3 years from the first part of the trial. Hugh Hearty, in December 2006, just a few short months before this document was created, was in the hospital in a medically induced coma. This power of appointment was only going to benefit him, and the family got together in terms of providing for a spouse. All the other beneficiaries and grantors of this particular trust had children or siblings that would take under the trust in which the trust share passes through. So Hugh was the only one. He had just recently faced a huge medical emergency where he almost didn't survive, and it was decided at that point to liberalize the power of appointment, but also, and perhaps more importantly for purposes of Lisa, to allow her to get a whole trust share. You can go back to that prior power of appointment. You can see it was very, very limited as to what could pass to non-blood relations of the Hugh or of the Hearty family. So this was an intention to allow Hugh to leave his trust share to his wife, and no one else would benefit in that manner. But as I said before, after spending days listening to the evidence, weighing the evidence, the trial court made the determination there was no question Hugh Hearty intended to exercise the power of appointment in favor of Lisa Hearty. That gets us to the point where we have to decide whether this instrument is legally sufficient. that goes back to the argument they have tried to make over and over again, that somehow by allowing this instrument to be legally sufficient, that it somehow invades probate code, probate law. That simply isn't true. Mr. Klista said that most property transfers in will has to be probated. I would respectfully disagree with that remark. In my experience, most people with a great deal of wealth particularly use trust instruments to transfer wealth. They do that for a number of reasons, many of which are good, and it's unquestioned, but they don't, in most cases, in fact, use an instrument that has to or needs to be probated. The court, in upholding, or if you want to say reforming the instruments, cited several standards of law, including the equitable power to reform an imperfect execution of a manifest intent, the allowance of a trial court or a court to effectuate the intent of the party, whereby mistake, accident, or ignorance, the power was defectively executed, and they have tried to make an issue about that. Well, we know what his intention are. That was established by the trial court. His intention was to fulfill this. There was a question about from the court about whether he had done that in the past, or if in the past you could make a inter vivos transfer. Well, the prior version of the power of appointment actually allowed a party to make an inter vivos transfer, but that wasn't effectuated until the time of death. So you have this hybrid instrument that is, in some ways, exactly like the prior power of appointment. Didn't require probate. It allowed you to make a transfer inter vivosly, but it didn't take effect, or it wasn't effectuated until the time of the death of the parent. That is actually set forth. It's, I believe, Exhibit C to the first version of the trust. It's the power of appointment. It's several pages long. That was done away with.
Okay,
Just real. Oh, I'm sorry.
just because I don't want to have a confusing question here. What if Mr. Hearty is in the hospital and he says, I want to find a way to transfer this to my wife on death, and everyone says, we'll change the trust so you can do that by will. And he says, I'm going to choose that. That's what I'm going to do. Okay? But it's not properly executed for some reason. Let's say he chose to do that, but he didn't sign it. If he chose to transfer it on death, and he chose a will, as opposed to one of these one of these documents that says transfer on death.
Right.
Don't we have to look, do we have to look at the probate court law to figure out if it's a valid transfer on death?
Not according to the will, or not according to the law that deals with trust, not according to the law that allows for equitable reformation. This is a trust instrument. This is a trust issue. There is nothing, and I couldn't begin to go through the analysis that was done in our briefing, but the analysis done in our briefing leads to the inescapable conclusion that even if this is an ineffective probate instrument, which clearly it is, that it satisfies the power of appointment for purposes of this particular trust. There's no language in the trust that disallows for it. There's no statute that disallows for it. There's no case law that disallows for this to occur. And when they come up here and they say that it violates the probate code and violates probate law, that's not what we're talking about, and it necessarily tries to confuse the issue. The remainder of the trial court's decisions, I say decisions because there's both Hearty 1 and 2, largely dealt with issues of fact. Again, we're really, once again, mixing apples and oranges when we come up here and we talk about the probate court and the requirements for an accounting, that sort of thing. This was a trust. You had the language that dictated whether or not the trustee was required to and obligated to pay the cost and expenses. The trust itself said that there had to be a reasonable evaluation or assessment by the trustee. And the trial court went into great detail to analyze not only the debts that had accrued, but also the assets, non-trust assets were available. That alone satisfies the requirement needed to support that part of its decision. However, and the most telling thing is, and this was an admission by the trustee, it's taken verbatim out of the transcript, I did not evaluate the claim, meaning I did not evaluate that claim for the unpaid debts and expenses. They were sitting back, and it was sort of going off track here, but this Homes partnership issue had been developing, and they basically were refusing to even acknowledge the debts of the estate, saying that this possibility of payment sometime in the future should be taken into consideration. That's not what the trust document provided for. And it's funny, they want to have it both ways. They want to have a strict construction when it comes to one part of the trust. Another part of the trust, they want to say, well, it gives me the latitude to consider, a payment that was made in January, the year after the death of the decedent. So, and it really shows you, and it's really revealing as to how this trust was handled, particularly when it came to Hugh Harty's interests. The Hardys felt that they knew best, and they were going to do what they felt was right. What they didn't do was what was fair.
Counsel, you're out of time.
Can I just two words?
Yes, you may sum up.
This has been a long time. These cases face motions for, initially motion to dismiss, motion for summary judgment. 2 separate judges have weighed and reviewed evidence and have issued rulings. 3 days of trial took place. It shouldn't come down to 20 minutes of argument, and I'm sure, all that other will be taken into consideration as well. I can honestly say I've not been a part of any other case that has faced more scrutiny. With all due respect to this panel, to second guess what those courts did below the court and those judges did below.
Counsel, you're a little more than a couple of words here.
I realize it. And with that, I'm finished.
Okay. You have your 4 minutes.
Plaintiff's position is that trust law applies. This is a matter of trust, not probate. But again, these parties made probate relevant by putting in the trust language that they all signed off on, saying that it had to be by a will. Counsel has admitted that this so-called codicil can't pass muster in the probate court. In fact, they tried to submit it to probate long after Mr. Harty's death, and the probate court promptly rejected it because it wasn't witnessed. It wasn't a valid codicil. The case law even calls such a document a lifeless scrap of paper. Until it is probated, it is not a will. And if it is not a will, it is not sufficient under the trust language that these siblings agreed to. On the issue of the debts and expenses, again, the trustee, under the full language of the trust, had discretion in a number of different areas, and the court is free to read the trust document itself. But even under the paragraph dealing with the payment of debts and expenses, it was to be the trustee's determination. And even the last sentence of that paragraph says this is all to be determined reasonably by the trustee. That language cannot be pulled out of context. The trustee's testimony, one-line comment at trial, I didn't evaluate the claim, cannot be pulled out of context. The context in this case is the probate context. The probate court has a system for marshaling debts, expenses, and assets, and that was what the trustee, in his reasonable discretion, was relying upon. If I could ask the court to read one portion of that 500 and some page transcript, it would be pages 350 to 361, where this discussion about ample assets available to the estate occurred. I would also like to comment on another easy part of this case, and that is there should be no money judgment against these Harty siblings. They were joined in this case, and it was argued that they should be parties simply to bind them to any declaratory ruling. And the trial court turned around and entered a substantial money judgment against them personally. My clients have asked me, why are we obligated to pay this money under this judgment? and I can't explain it. They said, I never received a penny of Hugh Hardy's trust share, never a penny of his money. Why do I have to pay hundreds of thousands of dollars? There's really no reason for that payment. There are hard cases and easy cases. The trial judge could not bring herself to pull the trigger and do the right thing under the law because of these soft factors of sympathy and intent, subjective intent. The law dictates a different result. This court has a broader role. This court has to deal not only with this case, but with the next 100 cases that rely on certainty of the probate code, certainty of what a will is and what it isn't, and this court has to follow the law, do the hard thing in this case, and rule in favor of the defendants. The easy part, I'll leave that to the court. Thank you.
Thank you, counsel. The court will take the matter under advisement and issue a written opinion that will be sent to both parties, as well as releasing it on our website. Thank you very much.